the Wildlife Conservation Trust and the Initiative for Climate Action.
Benisha, you're on mute.
Apologies. The Moot Association of Government Law College is hosting the second edition of the Wildlife Protection Moot Court competition. This competition is a first of its kind, dealing with complex issues such as wildlife conservation, sustainable development, environmental policy, rights of traditional forest dwellers, and constitutional law. On behalf of Government Law College, the Moot Court Association, the Wildlife Conservation Trust, and the Initiative for Climate Action, we warmly welcome you all to the panel discussion of the second Wildlife Protection Government Law College National Moot Court Competition 2020.
Today's discussion will be on conservation and the rights of traditional forest dwellers. Issues of environmental law and policy are a pressing matter in our generation. India is a country with a diverse range of ecosystems, each one presenting its own unique and peculiar challenge for conservation. Our panelists today will shed light on this and discuss the road ahead for conservation in India and how law and policy must aid this process.
I'd like to introduce our moderator for this evening's panel discussion, Mr. Rishikesh Chavan. Mr. Rishikesh is an ecosystem conservationist who has been working in the field for the past 2 decades. His work spans across various landscapes such as forest ecosystems, mangroves, and coral reefs. He has been a part of various committees such as Maharashtra State Wildlife Advisory Board, Special Task Force for Conservation of the Central Indian Wildlife Buffalo constituted by the Supreme Court of India, and the Committee to Assess Implementation of Forest Rights Act in the state of Maharashtra. At WCT, he leads the Conservation Behavior Division that provides technical inputs for designing conservation interventions. Additionally, he is involved in various management functions of the organization. I now request Mr. Chavan to give a brief introduction and introduce our esteemed panelists. Thank you.
Thanks, Benisha. Good evening, everybody. Thanks, Ria, for the introduction. And we really look forward to this panel discussion. Today's topic is conservation and rights of traditional forest dwellers. So climate change, the loss of biodiversity, degradation of forests and other critical habitats is extremely critical subject these days. And when people try to conserve the forest or try to mitigate the risk from climate change, what comes out very starkly is doing all of this by maintaining the rights of the indigenous communities who have been there traditionally and been using those resources and conserving those resources. So it's a global challenge, and India is no different to it. India also has several local communities that are dependent on these natural resources. So India as a country has laws to ensure that all these challenges are met. We have the forest laws and the wildlife laws. At the same time, we have laws on protecting the scheduled tribes and other forest dwellers. But the question is, are these laws in synchrony with each other? Do we have a way by which we can follow these laws, ensure the challenges are, we come over the challenges and basically look at the greater good. And today, we will look at the various facets from the law angle of this. And for that, we have a very distinguished panel with us today. And it is really my pleasure to introduce one of them. We have our 4 panelists. First on the panel is Mr. M.S. Reddy. He is APCCF and Field Director of Maharashtra Megha Tiger Reserve. Then we have Mr. Praveen Bhargava, who is co-founder of Wildlife First. We have Dr. Manju Menon, who is a senior fellow at the Center for Policy Research. And we have Rita Banerjee. Rita Banerjee is also been working in this field, and she has done a lot of work on, in the Northeast with the youth and stuff like that. So I'll start with introducing Mr. Reddy. Mr. Reddy is an IS officer of 1993 batch and has a very long distinguished career. His he was field director of Navegaon Nagzira Tiger Reserve, Pench Tiger Reserve, Bor Tiger Reserve, and of course Melghat Tiger Reserve. I don't think, or I don't know many forest officers who have been field directors of so many tiger reserves, to be honest. And his work is on-ground work is really appreciated by everybody, especially his work in habitat improvement and fire management. I'm told that Melghat Tiger Reserve this year saw 90% reduction in forest fires compared to the previous years, I think, which is remarkable. He also heads the only wildlife crime cell which tackles uh, poaching activities through a cyber data. They're looking at it. He has been his work has been highly appreciated for the voluntary rehabilitation of villages that he's done from core areas of tiger reserves. In his career, he has rehabilitated around more than 15 villages. He's also a Sanctuary Asia Wildlife Service Award winner. And I believe that Melghat is the melting pot of forest conservation and rights of forest communities. And we welcome you, sir, on this panel discussion. Next, we have Mr. Praveen Bhargava. Praveen Bhargava has been involved in wildlife conservation activities since 1992. He co-founded Wildlife First, a not-for-profit conservation organization, and presently serves as its managing trustee. He has represented Wildlife First on the National Board for Wildlife, the highest statutory body chaired by the Prime Minister. He was part of the subcommittee on amendments to the Wildlife Protection Act of 1972. He's currently a member of Supreme Court Inquiry Committee on Elephant Corridors. Wildlife First has played a catalytic role in ensuring that incentive-driven voluntary resettlement of tribal people in Nagarhole and forest dwellers in Bhadra. Wildlife First has also provided resettlement for families in Kudremukh and Nagarhole, volunteering to move out, those who were volunteering to move out with their own funds and the other donors, which has ensured real social justice for people. Then we have Manju Menon. And Dr. Manju Menon is a senior research fellow at Center for Policy Research. She undertakes research, writing, and community projects on environmental justice and the politics of resource rights. Manju has engaged with India's environmental laws and policies for over 2 decades. Her ongoing research projects examine the role of government, courts, citizens in environmental lawmaking and enforcement. She has co-designed and supports community-based projects that aim to protect social ecological commons, public health, and community livelihoods. Manju has published on these topics widely. And with that, we have our last panelist, Ms. Rita Banerjee. Rita Banerjee, I've been knowing her for a long time now, and her work is really in the space of filmmaking to begin with, where she has made several films on wildlife and issues of environment and people. In fact, she is an award winner of the Panda Award winner, which is considered to be the green Oscars in this country. And of course, she works in Northeast, and she's working with the youth of Northeast to look at some of the critical challenges and creating local leaderships through using her skill set and passing on those skill sets to the youth and making the documentaries which are sensitizing enough. And she has also a wide range of understanding of the topics of environment, forest conservation, local communities, and their dependence on the forest and how they conserve it. So we welcome all the panelists here on. So the format will be that every panelist will have about 10 minutes to speak on on the topic. They will present their points and through their experience and understanding. Once every panelist has spoken, we will open the floor for any questions from whoever is attending and members in general. Once those questions are answered, I think we'll again have another round of closing in statements from the panelists again, so they can, if they want to counter any arguments or if they want to, reinforce their arguments, they can do that in the closing session of their minutes, which will be 5 minutes each. And once that's done, we will have closing remarks, and that would be for the day. I think we have about two hours from here now. So really looking forward to listening to our distinguished panelist. Mr. Reddy, if you can take over from here, we will be happy to listen to you.
Good evening, Rishikesh. As a panelist, I will talk about this Forest Rights Act, which has come up in 2006. And we have Wildlife Protection Act, which has come up in 1972. And after this Forest Rights Act, which gives individual forest rights and also the community forest rights for the tribals and also other forest dwelling communities over different like unclassified forests, reserve forests, protected forests, which includes sanctuaries, national park, and also the tiger reserves. All protected areas are also part of this ambit of Forest Rights Act. And I am not going to in detail about this Forest Rights Act, but there are certain things which are happening which are going against the conservation after this act came into implementation. I am going to speak about those specific points here. Though this act has come up in the year 2006, in which it determines two kinds of rights. One is the individual forest rights and other is the community forest rights that is given for the Gram Panchayat as such. And the claimants will be generally the tribals who are residing near these forest lands where these rights are being claimed, and also the forest dwelling community who will be not tribals, but for the last 3 generations, if they are living near this forest, they are eligible for this kind of rights. 3 generation here, generation period has been given in the act, that is 25 years. So if the person is residing for the last 3 generations of say 25 years each, that means 75 years, there they are, even if they are not tribals, they are entitled for these rights. So under these rights, individual forest rights, forest lands are being claimed by the tribals and the forest dwelling communities, saying that when this act has been enacted at the time of December 2006, if they are in possession of this forest land, then they are using this forest land for non-forestry purposes, these forest lands can be given to them as a matter of right. And these rights are decided by at 3 levels of committees. One is at a Gram Panchayat level, there is a committee, and there is a subdivisional, there is a committee, and at district level, there is a committee. And in the act, it has been mentioned that the decision taken by the DLC, district level committee, is the final. So my queries about this thing is, one is there is no specific time limit which has been fixed either for determining the rights, for disclosure of the claims, or for admission of the claims. Now 2020 year is going on, still the claims are admission, they are even taken for admission right now also. People are even claiming, saying they are having this, possessing this forest land in the year 2006 when the act has come, and they are claiming for the rights. And these rights are not yet been decided, and the process is continuous. So there should be a time limit which is not mentioned in this act. This is one thing which I would like to bring into the notice of the panel. And when these rights are being decided, the forest lands are being put for non-forest use, there is a honeycombing of the forest, because the rights are not claimed at one particular patch of forest. Somebody is claiming 2 hectares in 1 acre. Some 10 people are claiming forest rights somewhere in the middle of the forest. So entire forest land has been now honeycombed, and people are in the name of the rights, they are moving inside the forest. Even the protected areas like sanctuaries and national parks and tiger reserves are not, they are also at risk. So second is, when determining the rights, there should be a proof that the person who is claiming this right should be possessing that land. And satellite imagery is one best way, which is unbiased, and which says whether the person who is claiming this right is, whether he is in possession of that forest land when this act has come into implementation. So, but in Maharashtra, this satellite imagery is not taken as compulsory, and even a person who is elder in that village says, no, this person is possessing this land since 2006, based on the statement given by some elderly persons also, the lands are being diverted for non-forestry use, and this is happening. And there is one clause known as critical wildlife habitat, in which if there is a protected area under which the rights are being claimed, after declaring this protected area as critical wildlife habitat, no further rights can be given on those protected areas. So this process has not yet been started in many of the states in the country. So large chunks of forest lands in tiger reserves are diverted for non-forestry purposes. So this is what is happening in India. This is about Forest Rights Act, which I told. I only given the problems which we are facing right now in the field. Thank you.
Thank you, Mr. Reddy. Would you like to kind of expand on your experiences, because the claims might have come all for you to clear on forest rights by the communities, and what has been your experience in it, and if there were any legal difficulties in them?
Right now, see, in Maharashtra, as per the act, the decision by the DLC, district level committee, is final. You know, once the collector heads a committee and he sends this right, he rejects the claim, there is no further decision. They will only can go to the court of law. Now, government has come out with one more saying people can re-appeal. So those claims which are rejected by the DLC ones, people are once again appealing in the Gram Panchayat one more time, and tribal department being a nodal agency, they come out with a notification saying ki, when the claims are pending with different levels, whether it is Gram Panchayat level or SDC level or DLC level, eviction of these areas should not happen. So even if the claim has been rejected by DLC once, they reapply and also get the extension, and so that they will be in the possession of this forest land for non-forestry purpose for longer period, you know. And recently now Governor of Maharashtra has come out with a notification saying ki even those claims which are rejected by the DLC, he created one more level known as divisional commissioner level, so they can reapply at the divisional commissioner level. So one level which is not there in the part of the act, by a notification under the powers given under Schedule 5 of the Constitution has been given, and now there is one more level which has come up in Maharashtra state. It is not there in all India. In Maharashtra state, one more level has come up. So this has become a continuous process, and we are facing a lot of difficulties. Whenever you find a person who is having encroachment on the forest land, when he said we applied at DLC level, so we can't touch them. Okay, it is a practical difficulty, and all those cases, all those sanctioned titles, they are not demarcated at the field level, because tribal department being a nodal agency, they are not funding this. So there is no demarcation. Say a title has been given for 2 hectares of land, a person may be in possession of more of such land. So there is no boundary. For field officers, it is very difficult to know whether the person is in legal possession of the land under the title, or it is illegal possession. This we are not knowing. Okay, there are certain practical differences we are really facing, and it is going against the conservation and also wildlife protection, definitely.
Okay, so you have been in Meerkat for a long time, even as DFO there. You have looked at rights of communities when it came to relocation, because you did a lot of relocations there. So could you just shed some light of how you took into account the rights of the local communities there when you carried out the voluntary relocation of the villages from Meerkat?
Whenever voluntary relocation program needed to be started, there is a condition which is mentioned in FRA also, and also under the different government resolutions issued by the government of Maharashtra, in which when a village needed to be voluntarily relocated, that village Gram Panchayat has to give a resolution saying we would like to move out of this protected area to some other outside forest area. So resolution is compulsory, and also a certificate from the district collector which says all the rights under Forest Right Act has been settled. Mean by that time, whatever rights which has been applied at different levels, let's say 3 levels, they have been settled. Whether they are rejected or accepted, anything, they have been settled. This certificate we get from the district collector, who is the head of the DLC, and after that we start a voluntary rehabilitation thing. And under Maharashtra voluntary rehabilitation thing, the rehabilitation, every family will be given a cash. There is a cash package, which is 10 lakh rupees per family, which we are giving. Here the family is not one single house. Even a house having sons and daughter, a family having sons and daughter who are above 18 years of age, they are considered as a separate family. So even the persons, children who are above the 18 years of age are considered as a separate family, and they are given 10 lakh rupees per family. Okay. In addition to that, if they are possessing any immovable property like lands, even the valuation of the land, 4 times the valuation of immovable property is also given as a rehabilitation package. This is the package. So when a person gets an individual title under Forest Right Act, that means he is having a forest land, which is in his possession, the title has been given. So even the valuation of that IFR land is also given under voluntary rehabilitation.
Okay. Yeah, thank you very much. I think that was very succinct and aptly put in terms of the laws and what are the provisions and what are the various notifications that we have. And we thank you for shedding light on that, because many times you don't don't get to know the on-ground implementation and what notifications come in. So thank you, Mr. Reddy, for shedding some light on that. So from here on, we move on to Mr. Praveen Bhargava. So if Mr. Bhargava, if you could just I cannot see you. Just maybe if you could, there you are. So if you could, present your case, we would be happy to listen to you.
Thanks, Rishikesh, and good evening, everybody. Since Mr. Reddy has spoken about the field perspective, I would like to broaden the discussion and address this issue from 3 different perspectives. One is ecological, the other is legal, and the third is issues related to social justice, which is also at the core of this particular issue, and we need to look at it carefully. First and foremost, what I would like to mention to the audience is that the fundamental ecological premise of this law is flawed, because it assumes that grant of individual and community rights will have no impact on conservation. In fact, Mr. Reddy also mentioned about honeycombing. See, the issue is forest fragmentation. India, as we go along, is going to lose some amount of forest land for both development and delivery of social justice. But 30 years of the best science in landscape ecology is telling us that fragmentation is the most serious impact on both at multiple levels, at the level of an individual species, at the level of a community of species, and at the landscape level itself, which has implications for climate change as well. And this is also part of a climate change discussion. So therefore, the worrying fact, however, is that many academics who in many presentations will talk in academia about the impact of fragmentation with very nice PowerPoint presentations and data, do not talk about this when this particular issue is under debate. That is shocking. And as an impact, direct impact of fragmentation coupled with hunting and so forth, charismatic endangered species, particularly large mammals which are in conflict with human interests, whether they are large carnivores or large herbivores like elephants or rhinoceros, are reduced to practically 5% of the range. In fact, people in Maharashtra will know about the case of Avni and how it became extremely difficult for the forest department to handle that situation. And a lot of people suffered and people lost their near and dear ones. And these conflicts cannot be resolved. And let me make it very, very clear that this whole idea of harmonious coexistence which is touted as some kind of a magical formula to deal with this issue, is a utopian myth, particularly so in the Indian context. India is not Amazon. Just like we oppose the huge safari-driven vehicle-borne tourism, the African model that we are trying to crash land on the Indian PAs, which are small. Similarly, the Amazonian model of harmonious coexistence does not work in many cases in India, other than probably in the North Sentinelese and some areas which are not part of the mainland. So we need to look at these aspects very, very carefully. The next point which I want to flag is about India's protected area system. India has reserved just about 4% of its forests for endangered species. Now, the question that I want to pose is that if India has not been able to resolve its development problems and deliver social justice to people using 96% of India's landscape, will it make any dent on the problem by removing or destroying or fragmenting the last 4%? The answer is a clear no. But then policy is not heading in the right direction, both with respect to development, where projects, mining projects and so forth, highways, linear intrusions are fragmenting habitats. So we need to look at this very, very carefully. Now, let us take the much touted case, for instance, of BRT sanctuary in south of India. It is often stated that tiger numbers have gone up because of the community. But I have been associated and have been watching BRT for the last 3 decades, and I've talked to people who have actually fought to recover BRT from the brink. BRT was completely knocked out by slash and burn agriculture, extensive hunting, timber smuggling, and so forth. And the forest department was also indulging in extensive logging, which was affecting the forests. And there were large swathes of land given up for coffee estates and so forth to corporates. So BRT was really going down. It was at that time when the Wildlife Act came in that a very charismatic deputy conservator of forests took over, consolidated the people into the current day settlements, stopped hunting or went after the hunting gangs, and following which other officers came in and they brought complete control over a situation which was going out of hand. And it took 25-30 years for BRT to recover under the Wildlife Protection Act. It did not happen from 2008 when the FRA kicked in. So these are some of the things that one needs to understand in terms of the ecological aspects. Next, I move to the legal aspects of this particular issue. Here we need to be very, very careful. FRA, Mr. Reddy spoke about the field realities. FRA, let me make it very clear to all the law students, is not a land grant law. It is a law to recognize pre-existing rights that may have been left out during the forest settlement process. The forest settlement process itself was an extremely elaborate process. I have read hundreds of reserve forest notifications, and the way almost 15 sections of the Indian Forest Act have to be traversed before an area is notified as a forest. And the important point is that while the reservation process happened, at least an area equivalent to the reserve forest notified, a wooded area equivalent to the reserve forest notified, or in some cases up to 4 times the area. And data, there is available data on this, I can't go into it in detail, was left out for the communities. What has happened to those lands? And to now say that there was complete historical injustice, I'm not saying there was no injustice. I'm not saying forest dwellers were treated badly. All I'm saying is to just say that there was absolutely, people were completely left out is incorrect. The next point which I want to raise is a constitutional one. And Mr. Reddy touched upon this. But let me point out that it is the fundamental right under Article 19 of every citizen to move and settle in any part of the country. if any law abridges such fundamental rights, it is ultra vires and void to that extent. And if I give you an example of Gram Sabha, a family of Gram Sabha of 100 families, if 60 people decide not to move out, but 40 people decide to move out, and Mr. Reddy or any forest officer or the government offers them resettlement, can a majority resolution of the Gram Sabha abridge the fundamental rights of the 40 people who want to move out? These are all questions that one needs to look at. And the constitutional challenge before the Supreme Court in our matter is about the legislative competence of the central government on land, enacting a law pertaining to land. FRA is land revenue and land survey. Because surveys have gone on, land is being, and pattas are being granted, titles are being granted. So it is willy-nilly a subject that involves land, and central government does not have any legislative competence to enact a law pertaining to land. Yes, under Article 252, the central government, if two or more states come forward, pass resolutions and empower the central government, then they can. Like the Wildlife Protection Act, the wild animals was not in the concurrent list when Wildlife Act was enacted in 72. So that's another point that I want to make. And the last point pertaining to legal issue is about critical wildlife habitats. 72 lakh hectares of forest land as of September 2018 have been granted under individual and community ownership to several lakh people. Not 1 hectare of critical wildlife habitat has yet been notified. I said this to the then Director General of Forests when we were on the board, that not a single hectare of critical wildlife habitat will ever get notified. And I will stand corrected when it happens. But till date, it has not happened. So which shows how lopsided the implementation has been. Now let us look at very pertinent issues pertaining to social justice. If you look at it from the people's perspective, which you have to, inalienable land grants, just like what is now being envisaged and granted under Forest Rights Act, have repeatedly failed. It has been done. There was Bhumi Swami rights, Grow More Food campaign, Ek Sali grants, Singdev scheme, what have you. What has happened to the almost 50 lakh hectares of forest land since 1950 have been granted in under successive programs and schemes, including the Tribal Forest Interface of 1990. What has happened to those lands? They've all gone. So therefore, and the fundamental point is 6,000 people in 600 square kilometers with 60 tigers, 600 plus elephants, and a market for forest produce being 6 kilometers away is a equation that is a situation that is a sure shot recipe for disaster, both for people and for wildlife. So we can't go be blindsided to these things. While we certainly need to deliver social justice and redress the injustices caused to people, the way we are moving forward is not the solution. The solution, therefore, in my view, and I have been part of 2 voluntary resettlements in Nagarhole and Bhadra, is a proper site-specific incentive-driven voluntary resettlement. Unless, and many people are willing to go out. And not just in Karnataka. I was on a boundary rationalization committee where way up in Uttarakhand, when I went and met villagers, we walked 16 kilometers and met villagers, they all assembled. They just said one thing. The first statement was that, Saab, humko rasta dijiye ya vistapan karige. And this is on record. It's part of the ministry's record. I was part of that committee. So therefore, and one important point that I want to make with respect to social justice, I know I'll finish in 2 minutes, is, do you know that more than 1 lakh crore rupees is allocated for the upliftment of 10 crore tribal people? And MOTA is handling this, Ministry of Tribal Affairs. along with various other departments, and under schemes which is called as the tribal sub-plan and etc. Scheduled tribe component under Article 275 of the Constitution. The question remains, why are the people still languishing? What is happening to this 1 lakh, humongous amount of 1 lakh crore rupees? I think we need to really introspect on this aspect. And therefore, we need to look at this issue from these perspectives, all the three perspectives. I'm pretty certain that we can craft win-win solutions for ensuring that people are really get social justice. I've seen with my own eyes how people have formed self-help groups in Nagarole, how they've come up. And let me tell you, yes, Nagarole is not 100, it's not Ram Rajya. There are problems. I'm the first to admit it, but not a single family has gone back. So therefore, we need to look at these issues in a very different, this is not we should not caricature this as anti-humans and wildlife conservationists or tiger versus tribal. And that would be doing injustice to this issue. And therefore, I conclude by saying that if we look at this from these three perspectives, I'm pretty certain that the country will come up with sensible policies that will not only take care of the interests of disenfranchised people, but will also ensure that conservation does not suffer. Thank you.
Thank you, Mr. Bhargava. I think that was quite a lot of information was compacted in short space of time. I think that was a wonderful job by you to put numbers together. I think, and you also opened it up for a wider discussion and kind of presented the need for discussion on both ends. So from taking this forward from here, I would like to invite Dr. Manju Menon to add her perspectives and her experience from field. She spent so much time in policy research. So I would like to welcome Dr. Manju, if you could come and present from here.
Yeah, thanks so much for having me in this panel discussion. And I mean, it was great to listen to Mr. Reddy and Praveen, before I use my 10 minutes, because I think, I mean, as a very experienced, field officer, Mr. Reddy has clearly laid out in very few words how difficult it is to implement any law, I would say, in the kind of socioeconomic context that we live in. And Praveen has also sort of expanded it to raise some important questions, which actually in many ways are the crucial questions that I think the students can clearly sort of open up as part of their debate. I would love to be part of that debate, because I feel that there's still so much, so many aspects of this question about people and conservation in India that still needs to be opened up. And I mean, I'm saying this knowing fully well that if one just steps back and looks at the extent of the number of studies that have been done in different places, whether it's academic scholarly work or it's field-based research that's done in different places, in the fields of anthropology, political economy, culture studies, what have you, environmental justice, all that. I feel that this point of as a society, how do we sort of strike a good relationship with nature in different places, I feel has been center to so many of their scholarly works, and history, of course. I mean, there's tons of work by historians on this. So I just want to keep all of that in mind and say that this is almost I mean, the question of people trying to figure out and trying to get the state to recognize how they use space, how they use land, how they use natural resources is a very old one. And it's been a constant struggle in most parts of India. If you go back to history, and this is going back even beyond, I mean, going back even more than 100 years. And one looks at all of those historical records, and it's quite clear that people have had to really struggle to ensure that the state, whether it's the colonial state in the past or whether it is the independent Indian state and its bureaucracies, to get the state to recognize that we have certain kinds of relationships with the natural environment around us, and we would like that to continue because our life depends on it, or our futures depend on it, whatever it is. So I just feel that, for a lot of us who look at this issue from the lens of environmental justice, it's really very difficult to ignore those, over 100 years of generational struggles that people have waged to ensure that the state recognizes their relationship to these areas. Luckily, I feel, considering that many of you, Praveen, Rita, many of you were part of the discussions on the Wildlife Protection Act when it was being amended. I feel like there was one point in the 2000s, early 2000s, when the Wildlife Protection Act embraced a community turn. So you have the introduction of community reserves, conservation reserves, various things, where there was an expansion in the models of protection for protected areas. And I feel that that was an interesting moment when there were lots of field experiments being tried out by a lot of young conservationists. Unfortunately, I feel that that space has kind of gotten cut off a little bit with the introduction of the Forest Rights Act. And the Forest Rights Act, I feel in many ways the Forest Rights Act has, of course, become a huge flashpoint between social activists, working on, Adivasi rights, land rights, and conservationists. But actually, in many ways, the kinds of safeguards that different communities had won through those hard-waged battles over the 100 years were already there in the form of different kinds of laws, whether you look at colonial laws, like, for example, in Jharkhand or in the Northeast, and also in the kinds of constitutional safeguards they had. But of course, these were obviously very patchy and very different for different regions. What the Forest Rights Act seems to have done is to create an overarching framework to acknowledge that there are these different kinds of communities who all have very close ties and relations, and their lives have been spent in forests. So I feel that the Forest Rights Act was basically, it came over all of these various kinds of legal and institutional mechanisms that were already in place, that were negotiated between communities and the state. And it obviously went beyond that, because most of these rights that existed before the Forest Rights Act were mostly, I think, in the form of usufruct rights, basically use rights, that if you have been living in these areas, you can actually continue to use these areas for certain kinds of purposes. I feel that the Forest Rights Act just pushed that boundary a little bit, maybe a lot, and finally established habitation rights. It finally established rights to self-govern those areas. And I feel that this actually came from, even these aspects actually came from the earlier set of rights, or the earlier set of laws that had already gained acceptance, which is the Panchayat extension to scheduled areas and things like that. So it's interesting that the FRA got such a, became such a flashpoint, even though it was building on some of these earlier legal regimes. And the FRA in itself, if one looks at it, it doesn't actually see everyone in the same way. Everyone who have, all communities who have habitations in forest areas doesn't look at them the same way. In fact, even today, if we look at the way the claims process go, the non-tribal communities have to work much harder to ensure that their claims are recognized. So in that sense, the FRA also tries, at least in whatever ways possible, to create a layer of rights for different communities, because obviously it recognizes the fact that different communities may have had different relationships with these natural resources. But so this is, so I feel that if one looks at Forest Rights Act in this manner, which I think many people have gradually started to do. Maybe in 2006, when it came up, it was not clearly understood, but then there've been over a decade of debates since then. And a lot of people today, I feel have reached the point where they don't necessarily, and Praveen himself said so, that it's not about whether we acknowledge that there have been historical injustices or not, but how does one implement the Forest Rights Act or the legal framework of the Forest Rights Act, given all the other values and objectives that we want to achieve in that space. So I feel that if implementation is the key question, then we should acknowledge that there's not that much of a debate. It's actually a way of figuring out what kind of governance mechanisms and what kinds of institutions we have to put in place, procedures, whatever it is, to get this done in different places. And obviously, different places will have different kinds of requirements. That brings me to the question about laws itself. I'm happy that Praveen, fleshed out the legal aspects of this whole thing. And I feel that it's useful to understand this in comparison with other legal frameworks, like, for example, the Wildlife Protection Act or the Indian Forest Act, let's say. I feel it's a comparative lens is really useful to understand lawmaking, because it seems that most of these laws, at least I can say for sure with the Wildlife Protection Act and the Forest Conservation Act, the Forest Conservation Act and the Forest Rights Act, these came through some form of advocacy. Somebody within the system or outside the system advocated for these laws, wrote up the first drafts, went and persuaded important, powerful people to actually pass them. And obviously, these laws didn't get passed the way they were meant. They were first written, because all laws can be passed only if they're politically viable. So the law itself may have some kinds of, the legal text represents, the kinds of discussions and negotiations that have to be done in order to set up, a text as a law. And so obviously you just like with all other laws, and I'm saying this because, I think many of us who work on environmental justice, we are not particularly wedded to one or the other law. And we also don't distance ourselves to one or the other law. We'd like to use whatever works. And if one looks at laws in that manner, you will see that there are contradictions and big problems in every legal text, which makes implementation nearly impossible. Like, you look at the whole idea of, since we've discussed this point in this discussion already, the idea of community forest rights and critical wildlife habitats. These two concepts actually come from two completely different philosophies or worldviews, but you find them in the same legal text. Now, they've been set up in contest with each other, practically. I mean, there's going to be a lot of discussions, which have already started, of which one should be implemented before the other, which one should be a precondition for the other. And so, you basically have these two concepts sitting in the same law and calling out for implementation. And we have no clue how we are going to do it. Because if you implement one, you might end up not implementing the others. So how do we untie these knots is completely dependent on creative use of legal and social spaces on the ground. And I feel that's where, I really appreciate, field officers like Mr. Reddy, because it's completely up to them about how they're going to untie, these aspects of the law. So I just want to get down to like a couple of points about conservation itself. I just feel that, we were talking about conservation even like 10 years ago in a sort of a very different way. And now, the big elephant, or whichever, the most ferocious mammal in the room is climate change. And that is going to have such profound impacts on landscapes, even without us knowing, without us being able to stop it, or without us being able to manage it in any way. It's going to completely transform landscapes. So I feel that one of the big things that, for me, conservation, outside of all the conflicts and, all the issues and problems that are tied to conservation debates. For me, conservation is actually a context or a space to really rethink or to reimagine how we produce and consume nature in today's context. Because finally, it comes down to that. Do we think of urban spaces as worthy of conservation, for example? It's a big question for a lot of us living in cities and now locked down in cities. It's a huge issue. Suddenly you turn around and you're like, oh, I can't go to Melghat if I wish to. I can't go to, Spiti if I wish to. So, but then I have to try and start figuring out, when am I going to think about conservation in the city, which is where most of us live. This is also, one thing that has come out so clearly in the last few years, but definitely in the last couple of years, is that young people have started to speak out so much more using the lens of intersectionality. Basically, let's not look at anything separately. Let's look at all of it together. So it's high time we actually took that cue and tried to rework conservation models and conservation ideas through the lens of race, class, caste, gender, and religion. I mean, extremely important. So I just feel that, this is such an important time for conservation and conservationists, and for all of us who love, forests and wildlife and rivers and all of that, to actually rethink, these kinds of conceptual separations we've created about urban and rural, about, certain spaces meant for conservation and others. And I feel that at this moment, no matter how much provocation there is because of the Forest Rights Act maybe, or because, we find that tiger numbers are dwindling or whatever, we should not actually go back to those older models which we had left in the early 2000s. We were trying to get away from that. I feel that if we go back to it, that'll be like accepting some sort of a failure, that we really can't think about this in any other way. So I feel like it's an open field for all of us to actually think and imagine, different ways of doing conservation and social justice. I'll stop there.
That was quite profound, Dr. Manju. You spoke about governance, and you spoke about the various, sections in both the acts and how they are kind of overlap in some sections. And the way to go forward would be to look at probably an act which is more in tune with the current demands of communities, as well as the demands of nature conservation and climate change and things like that. That puts it in a very interesting perspective on the FRA as well as the Forest Conservation Act. Generally, it's FRA versus the Wildlife Protection Act. So it's quite interesting how you've formulated your thoughts on them. So what we'll do is we'll move on from here and we'll go to Ms. Rita, who's actually, Rita, you are a Ashoka Fellow, and you you're the founder director of Green Hub project, and you really work with the youth and to look at social justice and also conservation action through youth. How do you think the youth is looking at FRAs or the Wildlife Protection Act, especially in the Northeast, which we know is slightly different culture from the rest of the country? So, Rita, if you could take on from here.
Thank you. Really, it's quite a privilege to be on this panel actually with Mr. Reddy, Praveen and Manju. And I think these discussions, the presentations till now give such a rich perspective on various aspects of the law as well as what is happening on the ground. My experience is actually, I come from another background. I've been originally a filmmaker, a wildlife and environment filmmaker. And from there, the path has led to working with the youth. And I think most of my learnings about conservation, whether it's community conservation, whether it's working in protected areas, working with the people or filming with, with various issues related to forest, I think the learning has been on the ground, looking at various issues, somewhere where the laws play a huge part and somewhere where you wonder how it can be implemented, like what Manju was saying. So if I look at the Northeast region, in fact, with the FRA, it's a very complex situation because most of the Northeast states, most of the forests, as you all know, belong to the community. And there are a lot of customary laws related to forest protection. So many of the states like Nagaland and Mizoram, they haven't really accepted the FRA because they're also protected by 371. And because the forests already belong to the community. So it's a very complex situation in that sense in the Northeast area. And, but I guess I'll speak more from the experience of what I feel about conservation as such. And the reason one started working with the youth, was that one felt that there is a disconnect between the understanding of conservation and the connection with the forest and the rivers and the connection with conservation. While in the beginning, when we were filming with communities with hunting. They were hunting in their community forests. Many of the forests had become silent. At the same time, the knowledge which the community has about the forest, about their land, about their rivers is huge. So where is that disengagement? Where is that disengagement where the youth feel that those natural resources are not of value, or where the youth feel that this is not the future? And that is one of the reasons we started working with the community and with the youth especially to understand where was this gap. And I think that is, if you look at it now, it's a mix of everything. I mean, you have areas in Arunachal, in most of the Northeast, which belong to the community and still have some of the most virgin forest areas which still have not even been explored. And the laws don't apply. I mean, you don't have the FRA coming in there. At the same time, there are other threats where we are looking at infrastructure development, where we are looking at dams, where we are looking at mining, where we are looking at coal mining. So I guess the struggle is that how do you, while the laws exist, where is the, what is the way forward actually in conserving the natural resources? How do you remove the gap? So when you talk about, I mean, only recently from April onwards, once, during this lockdown, we've seen a beautiful movement where the youth have actually got engaged with conservation, engaged with much of the debate around all the issues happening now have been raised by the youth. And there has also been an intersection of discussion on laws, discussion on through various ways. So I guess I think there's a huge need. There's a huge need to kind of increase the conversations or dialogue between what the laws are and what it means to the community. I think while the laws exist, the understanding in the community on the ground, I think there's still a gap. There's still a gap. Until that gap exists, we don't know what will work where. At the same time, one knows that on the ground without the community, I mean, that's what the experience has been here, that without the engagement of the community, it's very difficult to talk about conservation or talk about a future or talk about livelihoods, especially in the Northeast region. So I guess when we're looking at laws, I mean, right now we are working with youth using video as a tool to really record stories or document stories in the region. Most of the youth belong to the indigenous communities. They are from the areas where we are talking about. They are from areas where their own community owns those forest areas. So through the videos, they're capturing those stories. Through the stories, there's an understanding of what is happening with their land. And through that understanding, what is actually a sustainable future, or what can the idea of development or the definition of development, can it be defined differently? So through this process, what one understands it, that while there are a lot of discussions, like Manju said, amongst us in a certain circle, in the urban circles, when we go to the ground, are we really discussing those laws there? So what is the role we need to play to really bring a larger or more holistic understanding of what is required, or how can it be used effectively on the ground? I don't think we have the time to kind of I don't think there's a time to take stands on extreme sides. We do need to come together. We need to have discussions like that, where we have different views, but we come to an understanding and see what really works on the ground and how we can take it forward. So for example, right now, in some of the areas, just to give you an example, for example, recently in the Karbi Anglong area in Assam, there were a lot of reports of hunting, especially hunting has gone up, pangolins have gone up. And yes, there is a act which can be implemented, the reports can be done, but at the end of it, unless you're working with the community for long-term change or behavior change, or you're really working on the ground to understand the larger definition of conservation or learning from them, it's a both way. It's a process which works both ways. So I think how do we bring in that change? So I think working on the ground with the youth, making them understand the various aspects which are linked to conservation, and through that approaching law, through that approaching the various concepts, through that approaching different ideas of community well-being, one can say. I think that is very essential at this moment. How does one, for example, let's talk about one of the key things. I mean, Northeast, one has seen recently, I mean, there are big hydro projects being proposed, there's mining, there's also the oil palm plantations, which is being promoted. A lot of the land belongs to the community, and they are giving it away for mono plantations. But after 10 years, 15 years now, when they see the returns, there is a huge water crisis. The returns they were getting earlier from doing a traditional form of farming compared to what is happening now, including rubber plantations, the impacts are showing now. But is there a learning from that? Is there a learning from there, or is there an effort from different groups, whether it's government, whether it's NGOs, whether it's the community, to really look at why it happened? Like Manju mentioned, the whole climate change impact. So one needs to have a really holistic perspective about conservation. and also a holistic perspective about what we are saying when we are talking about development. Even now, the development model which is being proposed is based on infrastructure, even in the Northeast, which is one of the most biodiverse regions left. I mean, it's changing very rapidly. There's huge deforestation. In fact, the fastest rate of deforestation was seen in Assam. But are we thinking differently now? Are we trying to bring in a new paradigm or new thinking which looks at a future which is embedded in ecology? Are we really looking at a green economy in its true intentions? I think that is where I think all of us, whether we are looking at law, whether we are working on the ground, whether we are working with communities, I think it's very important to bring that process through. And I think the reason I think youth are playing a big role is because if their voices or their understanding deepens, if their voices are stronger, they are the ones who can, I think, take it forward in a much stronger way. I think they can play a big role in changing the narrative of conservation and wildlife, of how we even look at laws, or how we actually make it effective on the ground. I think that's what I'd like to say, and maybe we can take the discussion forward.
Thanks. That was quite an insight from the field, actually, of what's happening there, how do people perceive and things like that. So what we will do is, like, I would like to kind of ask questions and tell the audience that if they have questions, this is the time that they can, put it in the chat box, and the people from the Government Law College will kind of put it together and send it to me. But while people are asking their questions, I had a few questions. Let's say, for example, Rita, for you, like, you've been working with the youth for so long, and these acts are complex, as we evidently, or everybody knows. How do you give that understanding? Because you spoke about the gaps that is there, you need to have conversation. How do you explain these complex laws to the youth or the local community? What's been your experience, and how do you do it?
Well, it's in fact, you can say it's not like we have a very intense process where during the fellowship, the fellows are with us for almost 1 year, and when they are with us, it's not that we're talking about laws so much. It's really first understanding the definition of conservation, And actually, our learning has been very beautiful in the sense that when you have the 20 fellows living here, somebody from Nagaland, somebody from Arunachal, somebody from Assam, even within the Northeast region, understanding each other's states is very important, because even within the Northeast, it's different, right?
Right.
So I think we missed the point that law comes, I think, I'm totally talking about from what I've seen here, law comes much later, The first understanding is just about the fact that they have community forests. What does a national park mean? What is a protected area? What is a community forest? Even when you visit an area which is a community forest, that gets divided into private land, then a community land. Every village, every state, every area has a different customary law, different laws governing the land. So I think the first step where we are working at is looking at the mind shift change towards, the problem here is not the law. The problem here is that they're not looking at the natural resources as something which can create a future livelihood or sustainable future for them. So our engagement is more to make them understand that yes, a sustainable, equitable livelihood is possible, enterprise is possible, and there are many examples of it now. So how do you amplify that voice and move away from the entire narrative of moving to an urban area for a livelihood, which now in COVID-19 has totally shown the collapse of the development model, So unless we amplify this narrative really in the true intentions of it, I'm not just saying for the books, but really work with the community, work with things which are possible to do. whether it's sustainable farming, whether it's community-based ecotourism, whether it's green energy, but really work in a holistic way, work with weaving. So it's really important. I think we are just at the first step, and then I think there are people who are working with law. Like right now, we are collaborating with something called Studio Nilima. They work with law, and so we were having a discussion on how can we collaborate and how can they bring in the perspective of law. So I think collaborations with different people is very important to change that narrative and really work on the ground. So I think that's how I'll put it.
Yeah, quite pertinent. First, you need to understand the preambles of law and the larger idea of which direction we are going in. That's fantastic. Taking a cue from you, Rita, I would like to go to Mr. Reddy, where, Rita has been speaking about sustainable futures for the communities, and they kind of lack the knowledge to understand, or the perspective to understand that taking care is eventually going to help them. You have seen a lot of backlashes that come from unhappy communities. And why do you think there are these backlashes from the communities? And how do you think the forest department, how do you as forest department ensure that it doesn't happen? Mr. Reddy, if you are, do we have you, Mr. Reddy? I think there is some issue, but okay, till we get back to Mr. Reddy, Praveen, you have been in the thick of things when it comes to law, and you have quite nuanced understandings of different laws and what they cater to and how they kind of try to achieve the common good. As you said, that it's not about people, anti-people law. So you have looked at these laws. What do you think? Is there a need for any amendments or the interpretation of these? Say, for example, Section 5 of the FRA talks about conservation, right? So have you kind of looked at it at how they need to be interpreted, or the community reserves or the conservation reserves in the Wildlife Protection Act? How do you look at it, and how do you think the law should be interpreted in that sense?
See, my view is as follows. Interpretation has become a rather difficult aspect, for the simple reason that the lawmakers have enacted overlapping laws, and there are serious contradictions in these laws. For instance, non-timber forest produce. The way it is defined, Wildlife Act does not have a definition of non-timber forest produce, but falls back on the definition in the Indian Forest Act. That is what Section 2, subsection 12B says. If you take the interpretation from the Wildlife Act of a trophy, honeycomb is a trophy. In the Forest Rights Act, it says all non-timber forest produce of plant origin, including honey, cocoons, and wax. Now, I think we need to get to the basics when we are drafting the law. And there are multiple contradictions. In the Wildlife Act, it says that once the preliminary notification is issued, there is a bar on accrual of rights. In the Forest Rights Act, it says everybody shall be granted rights. Now, at field level, reconciling these is it opens a Pandora of problems. And therefore we need the lawmakers, and there are principles of law where the parliament, if 2 or more laws are already operating in a certain field, the parliament must ensure that the law that is being enacted is harmonious. There is a concept called as rule of harmonious construction. And that has to be followed. Otherwise, at field level, there's going to be a lot of problems. If we take specifically of the FRA, look at the first version of the bill that was introduced in Parliament on 13th of December 2005. Look at what we have today. There were 3 safeguards in the original bill. The first one was the cutoff date for recognition of rights was October 1980, when the Forest Conservation Act kicked in. Second, the law was meant only for tribal people who are recognized and defined in the Constitution. This nebulous category of other traditional forest dwellers, even probably I can kind of explain my way into becoming another traditional forest dweller. The third aspect was the protected areas had been separated out of other forests, and said that if voluntary resettlement is not completed within 5 years, the provisional rights granted in PAs would become permanent. All these three safeguards were dismantled by the Joint Parliamentary Committee. And we have an act today which is practically, so let's come to the specific issue of 13th December 2005, which has now become the cutoff date, which is in fact causing the maximum amount of problems on the ground. And several satellite imagery analysis, and I have seen probably more than 1,000 images of before and after. Pristine forests have been cut, occupied. I have applied for under RTI for documents, and rights have been granted. You take Telangana, you take Maharashtra, you take Odisha, many places, Karnataka to a lesser extent. So therefore the shifting of the cutoff date has had cascading impacts on the implementation of the law. If we were to have had the first version of the bill, probably then this issue would not have led to this much of acrimony. The last point I want to make is that these kind of laws have the potential of misuse. All of us know it. And every political leader in every state at every point for political expediency is using this law. Telangana, there's already talk that the cutoff date will be shifted to 2014. And already in Andhra Pradesh, the Chief Minister has announced that everybody will get 3 acres. Now, where is all this stated in the law? And how will academics or social groups or wildlife conservationists tackle these issues? We do not have the wherewithal. And what will field officers like Mr. Reddy do on the ground? They'll all crash land on them. So therefore, we need to be very clear. There is a way forward, and it is not just in the letter of the law, but when these laws are enacted, you need to look at which are the laws operating in the field, and then enact laws which can be implemented on the ground.
Right. Thank you very much. And you kind of hit the nail on the head, where the issues that come up when laws are not designed with the idea that it came up with. So, Mr. Reddy, we wanted to understand from you, like, because of these complications and sometimes misinformation going that, oh, if you get an if you claim a land, you get an IFR, and then you can go dead back and all of this. We've seen that, especially in some areas that you have worked, that there has been a backlash from the unhappy communities, as they have been coming back, and there has been really a big backlash on it. And what do you think are the reasons that such backlashes happen? And how does Forest Department ensure that nothing like this happens? What's your experience on that?
No, I didn't get you. There is the person who have been got FRA rights.
So we were largely speaking about, rights have been settled, or in cases where voluntary relocations have happened. We have seen that, communities have come back unhappy, and there has been backlash.
See, the government GR says if a person accepts cash package of 10 lakhs, he will not be given any more agriculture land, because either he should ask for agriculture land or for a cash package. All those persons who got rehabilitated are under the cash package. Now they are saying we want more land, which is more than what is there written in the law and also rules framed under voluntary rehabilitation, which is their extra demand. So they were even motivated by the politicians, and they were saying you go back to the forest so that people will listen, administration will listen. This is how they came back. So they were told what your demands are not right and they are not under the legal framework, and they came out. Okay. In the process, there was a clash between forest department and also the tribal. Some of my forest staff were attacked by axes, and they were brutally attacked, and they were all these things happened. There was this because it's all beyond what is written in the law. Coming back to FRA, see, FRA, like Praveen is saying, it is an act which is now considered as a distribution of the land. Forest land is distributed to get away from the historic injustice which has been done to these communities. Okay. So he has given a figure that 72 lakh hectares of forest land has been distributed under FRA under the claims. That means it is equal to 20 times the total area of the state Goa, or equivalent to the state of Bihar. So almost the area equivalent to this big states or 20 times area has been already, forest land has already been given in the name of individual forest rights to the people. And this land which has been given, will it come back? Will it have a tree cover? No. Once it is gone forever. It is totally put under non-forest use, and there will be no trees, no wildlife which will come in future, in long term. Okay. So there should be a time limit to which this law has to be implemented, and the claims has to be taken. So there is no such time limit fixed in the law. Even now in 2020 also people are saying, yeah, we are in the possession of this forest land in 2006, and people are now, the committees are going on, and it is becoming a continuous process, and forest lands are under tremendous pressure. Second, tell me, who is the owner of this forest land? Is it only the human beings living in this world, or the 10 million other species which also have the equal right over this land? Are not they living in this land for the years together? Don't they have the rights over this land? Do only the human beings have? If you give the voice to these animals and listen to them, what they will say about us, because they are voiceless, the trees doesn't speak, animals doesn't speak, we are just taking away their habitation and distributing in the name of all these things. What is happening? So there is an emotional, sentimental thing. So next, the biggest issue which is happening in this world is the climate change. I will say climate change. The only one of the factor which reduces the climate change with is the forest. Now this 72 lakh hectares of forest land which were having forest has been denuded of tree cover. Now this is it is going to aggravate the climate change which is going to happen now. If you see the rivers which are flowing from forests are the origin of the rivers. If you see the rivers which are now flowing, they are with full muddy of water, because earlier the water used to be very fresh. Now the water coming out because it is coming through the agricultural lands and it is muddy, and the life of the river also reduced, which were perennial earlier, they are now not even flowing for 4-5 months. So where we are going now? I am totally for the tribals. Their livelihood should be instead. I am not saying, see, there is always a discussion, tiger versus tribals. So I being a human being, I also ask for the tribal. But the way in which the historic injustice has been done to mitigate that, the way we are proceeding towards is not the right way. In my opinion, this is my personal opinion. Okay, as a government servant, I can't say it is the official opinion because it is the this one. This is my personal opinion. So those species which doesn't speak, now there is every year so many species are getting extinct, and where they are growing, they need a land to grow. Their habitation, their habitat is getting destroyed. At least protected areas, which are 4% of the total land mass, they should be kept safe for these wild animals and also these species. Even there are now no critical wildlife habitat has been declared, like Praveen has already said. Even after 15 years of implementation of that, not even a single hectare of land has been declared as a critical wildlife habitat, whereas 72 lakh hectares of forest land has already been diverted for non-forestry use. So in which direction we are going? So that is very important, and we should all think about these things.
Yeah. Thank you, Mr. Reddy.
Thank
you. Listening to Praveen and Mr. Reddy, the question, naturally transitions to Manju about, you heard them speak, and can you suggest a model or an example to follow where communities through local governance have been able to or create systems that are sustainable, equitable, or use of natural resources has been there, where it does not have to go out of hand, the laws, or where people think of FRA as a land grab opportunity and things like that.
You saved the biggest question for me. Not fair, but I'm still going to attempt it. It's. I mean, I'm so glad Rita, being where she is in the Northeast, working with young people who, especially if many of them are from indigenous communities of the Northeast, they carry with them a huge historical, psychological trauma of being located in a place that has been called underdeveloped, backward, primitive, whatever there's many names that have been used to describe them. It's full of racist slurs that, the language that we use to describe the peoples of those areas are full of this kind of nonsense. And I'm so glad that she brought up the issue of development projects in the Northeast. I mean, I've done a little bit of work on the hydropower projects in that region. And as she said, a place which is like it's wonderland. Every different parts of the Northeast that you go to is like a biological wonderland. There's still so much that we need to understand and figure out about those places and the plant and animal life living there, and also understand the communities who live over there and how they have engaged with their environments over so many years. But you look at what a large number of institutions are actually doing in that region. They are sort of really pushing down a certain kind of development down their throats. First, they say, this development project will bring you money, it'll bring you roads, it'll bring you lights, whatever that is. If they don't agree with that, then they resort to these racist slurs, that this place is so primitive and it has to be changed. You never allow, our developmentalist state does not allow people to feel proud of who they are and how they've lived over a long period of time. We are all expected to change. And if we stand in the way, if we resist that change, then there are implications for us, our families, our communities, and what have you. And those implications are quite nasty. You can take the example of Bastar, you can take the example of where is the Pathalgadi movement in Jharkhand. I mean, it's all over the place, right? So, I agree with so many things that Mr. Reddy said about who does the space belong to? Is it just for us human beings, or is it for the animals and other species that populate this world with us? But I wish we would make such a passionate plea to change the development model of this country. I mean, the statistics that we have only from the Forest Conservation Act approvals, the forest clearance approvals, and the now is the season of denotifications, I think, right? There's some stuff happening, some big stuff happening. If we all actually raised our voices about that, then actually we would realize that there is a lot more in common in the agendas that we have as people who want to conserve spaces and landscapes, and the people who actually live in those places. Like, for example, our greatest learning ground is in Chhattisgarh, where mining, local communities, and elephants being the representative of all the animal world. I'm just taking elephants as a representative. They have come to meet at such a difficult point, and it's just so difficult to find a way out unless you get the mining guys out. It's so difficult to do that. When mining is on the cards, when mining projects are on the table, everything else reduces to insignificance, whether it's human lives over there or whether it is rivers and forests and trees and all of those beautiful things, and the animals. I mean, and then there have been incidents in that area of villagers being very upset that the elephants have changed their routes and gone into fields and sort of rampaged standing crops and all of that stuff. And this happens in Assam so often, isn't it? But that's a systemic, that's a symptom of something something much bigger that's happening in that area. And all of us, with all our with our votes or with our voices or with all our educational backgrounds and qualifications, all of that, we are not able to do anything about it because you can't move mining off the list. And that's the kind of activity that practically destroys landscapes. You can't put it back together in any way after that. And at least I haven't seen it. So, I feel that this is not a direct answer to your question about a model, but I think before we think about that model, I feel that there is something that we must think about solidarity. Who are we actually fighting against? While, what are the powers that can actually consume everything that all of us stand for? So I feel that the question about the developmental model and how it makes us all unfree to be what we want or to, sort of appreciate and be attached to the things that we want, I feel that deserves a huge response, and we have to do that together. Otherwise, it seems like we are all fighting our little battles, and the message gets lost in all of that discussion.
Rishikesh?
Yeah. Sorry. Yeah.
Can I just add a few points?
Sure.
I agree with Manju Menon's assessment on the impact of development. She's right about mining and so forth. We've fought many mining companies, and they've been pitched battles right up to the Supreme Court. The point here is that, for instance, Dibang was a point where I try to help some of the local groups there and even good ecologists who are trying to fight for that. So that apart, what I want to mention here is that this whole idea of development versus forest rights also needs to be looked at from a data perspective. If we look at data submitted in the Lok Sabha, between 1980 and 2016, data submitted in a written response in the Parliament states that 6.33 lakh hectares have been granted for industrial and development projects in a span of 36 years. And that has caused problems, that has caused impacts to local communities, that has caused fragmentation of habitat. We are all agreeing on that. But at the same time, the worrying fact is between 2008 and 2018, 72 lakh hectares of forest land have been diverted for both individual and community rights. It's not just individual rights, as Mr. Reddy once mentioned. It is both individual and community rights. If you take only individual rights, it comes to about 21.5 lakh hectares. 6.33 versus 21.5. That doesn't take away from the fact that what Manju was saying about Chhattisgarh and Northeast and the development impacts. I've personally fought development projects and faced the consequences of it. I was slapped 14 criminal cases spread over 4 courts in 3 districts. So I know how ugly mining companies can get. So the point remains is that, so therefore, we need to relook at this sustainable development model or paradigm. This is not working. Because doing little things everywhere and then, no, we'll do that, we'll save this and that, it doesn't work. So John Robinson of WCS came up with a paradigm called as sustainable landscapes. We need to really look at it and see if that is what fits the Indian perspective. And what it simply says is there are certain areas which are absolutely irreplaceable. They must remain areas. I won't use Jairam Ramesh term no-go. I don't like that term. But they must be preserved for posterity. And intergenerational equity, precautionary principle, whatever you have, those must be locked up. And there, I won't even say inviolate, because you can't have an inviolate area. You may have areas with no incompatible human uses. Then you look at the next layer, which is multiple use areas, where you do have communities, you do have some amount of collection of non-timber forest products, etc., etc. And then you need to smartly look at where can industry and other infrastructure be sited. And you need to come up with powerful solutions. For example, linear intrusions. How do you resolve linear intrusions? For instance, we have been talking a lot, and finally, when we raised it in the NBWL in 2007, in 2010, they finally accepted if you can design a bypass road to divert traffic from Delhi, obviously you can do it for our critical landscapes, or the overpasses and underpasses and the recent bench thing. It was not really the best solution, but it was a solution nonetheless. And for instance, power lines, you can go underground for 400 kV DC power lines, HVDC power lines can go underground. So there are a suite of solutions that can be used to balance conservation and development. And the Forest Conservation Act says that only projects of site-specific nature will be allowed. If you disaggregate a project proposal of mining, say for example, only the ore body has to be located where the ore is. The township, the other infrastructure, etc., can all be elsewhere. So even if in a certain place you, in supreme national interest, have to mine, we can consider that. The second is the mining policy itself. It is all flawed. And you are assuming that India's per capita consumption of ore is 20 kilos, whereas developed countries are 200 kilos. And you're giving away mining and areas for project proponents. And look at Bellary, what happened? The entire ore, and 60 to 70% rich ore in Bellary has gone to China, whose ore reserves are far, far higher than India's. Why should India export minerals? So these are all questions that need to be reconciled. I do not want to drag this debate into how development can be reconciled, but the short point is that we really need to look at it. There are powerful solutions, but it is a real challenge today for ensuring that these really get into policy. I was hoping that Niti Aayog would be that kind of a catalyst, but Niti Aayog unfortunately has just not lived up to its mandate. And there is no infiltration of good knowledge and information in policy making. And that's why we are getting stuck.
Rita, you wanted to make a point?
Yeah, I think just taking from what Manju said and what Praveen has said, that, I think one core thing is, how do you actually, we have actually, a lot of us are on the same side, whether we are talking about, when we talk about sustainable development, we are also talking about livelihoods of people from rural areas, from indigenous communities. And we are also talking about preserving forests and wildlife. Actually, if you look at it, somewhere there on both sides. In the debate which happens in our country, one big gap I've seen is that we talk about rural development separately from wildlife protection. The wildlife organizations say they're working with wildlife and people, And rural development, they say they're working with rural development. And actually, there are fantastic examples in India when you're talking about this thing. In rural development, there are fantastic examples in central India on watershed development, where now you have from a dryland area, the water level has gone up because of watershed development, but we don't look at it as a wildlife and conservation thing. It is actually very linked to climate and conservation. So from that watershed development, now the farmers of that area, which had huge migration, has a collective of 20 to 30,000 women who are selling their produce directly to the market without the middleman. Now that's a very powerful story actually of environment conservation, of sustainable development. At the same time, there'll be a group working on wildlife nearby, but these two groups need to meet, because the work which a wildlife organization is doing with science and communication and data is equally important to a group which is working on watershed development. And these two groups have to come together to talk about landscape level development. So I think it's very important to also not work in silos. You have a ministry of water, you have a ministry of forest. Why is it separate? Actually, it's very important to link these two things up. So I think right now the scale at which all our work needs to, I think the scaling up is very important. And in that scaling up, landscape conservation is very important. And in that, I think we need to work together, and not look at it as separate issues. Because there are very powerful examples of development in India, of rural development and linked to conservation, absolutely.
Yeah, well made point actually, that we now need to move away and look at the current challenges and a change in how development has to be, how the laws need to be looked at. So we are at 6:45 now, but we have the luxury of extending the time. So slowly the questions are trickling in from the students, and I think I have 3-4 questions here. So first one is for Praveen. It's from Zaman Ali, and he is asking, since the protection of forests under FCA and IFA continues in addition to FRA, on what basis are you saying that fragmentation is entirely attributed to traditional dwellers? Please share your source, is what he is asking.
No, I said that fragmentation, one of the causes of fragmentation is the grant of individual rights under the FRA in an ad hoc manner. I have also said that despite the FC Act and despite the Indian Forest Act, development projects have also caused fragmentation. So it's a multiple assault on forests. The way one you can look at this is that whatever is the impact, whether it is an encroachment, whether it is a development project, the first goal must be to ensure that large blocks of forests are not fragmented into bits and pieces. Because as I said earlier, that the impact can be at multiple levels. So that is the goal. And I'm very, very clear in my mind that with Wildlife Act, FC Act, and the Indian Forest Act, there have been huge problems with respect to limiting fragmentation. Aspect of fragmentation at all. And therefore we need to, it is not that the law is incorrect, it is the implementation of the law where there is a problem. And in terms of policy, for instance, under the FCA, for my friend, let me highlight, there is a slab system for clearance. Up to 5 hectares is cleared at the state level. 5 to 40 hectares is appraised at the state level and it is sent up to the Secretary, Ministry of Environment for clearance. And above 40 hectares goes to the FAC. Now, imagine a situation where there is a 4-hectare project in a 100 square kilometer block of pristine forests versus a 50 hectare project in a fragmented bit of 10 square kilometers. So my suggestion is you have to turn this upside down. You have to look at it from the perspective of fragmentation in terms of where that project is seeking clearance. And unless and until, and this comes from an understanding of ecology and from a landscape perspective. You talked of climate change also. There is clear data to show that you need to maintain connectivity between, say, different habitat types from scrub to evergreen forest, because vegetation is moving up and we have no control over it. So certain species will just get extinct because they can't move due to fragmentation. So there are multiple issues. So the point, short point is that there's nothing, no problem with the law and the Indian Forest Act or the FC Act. The problem is with respect to implementation, and we are not applying this filter of fragmentation while clearing projects. And that is causing problems. And the FRA is causing problems because people are ad hoc. For instance, see the last point, sorry, Rishikesh, this is important. There are two ways of reconciling it. People, okay, let us assume that people must be given land. We will give land, but where do you give it? If you bring people to where the services are, you will ensure that there is no fragmentation and services that you and I enjoy are available instantly to the people. Whereas if you give small little pockets of 5 hectares, 10 hectares in the deep interiors, then the rural department, I think Manju mentioned about rural, or I think Rita mentioned about rural development projects and so forth. They will drive a 5-kilometer road inside. That road will not last. They'll build some school where no teacher will go. What are we doing? So we need to look at this very, very carefully.
Manju, do you want to add?
I was actually thinking about the earlier point that Praveen made about sustainability and looking at sustainable development and stuff like that, and I just wanted to point out about this new, I think what's going to become a new conservation nightmare is, large scale renewable energy, solar farms, for all, from every point of view, it ticks all the right boxes in terms of sustainable development, reducing carbon emissions, reduce mining and all of that. But the scale at which they're being taken up, on what are called, this almost a government fiction of wastelands, is going to be crazy. I don't know if, considering the amount of focus that the conservation world gives to protected areas and, forested landscapes and large megafauna, I don't know if these spaces will get the kind of conservation attention it deserves at this point, because, once, I think the genie is already out of the bottle. So, I just felt like I should bring it up,
Okay.
that sustainability also means different things, and the scale at which it happens can be quite scary.
Yeah, I completely agree. Everything has been reduced down to carbon dioxide, and nobody really looks at, what grasslands are being termed as wastelands. And yeah, it is. I think it's very pertinent when you look at such developmental models. Here, I would request the participants of the Moot Court, if they have questions, you can just unmute yourself and ask a question to any of the panelists, because you guys have to then, prepare for tomorrow, and then you have a competition. So if you have questions, just shoot them straight away, just unmute yourself, introduce yourself, and you can ask your questions to the panel. So we'll wait for a couple of seconds if anybody unmutes. Otherwise, so this program is also live on YouTube, and we're getting some questions there. So if there's some, if we are not getting questions from the participants here, I can take up another question that came on YouTube. I think we'll give participants some time, but here's the question. I don't know who it is addressed to, but so whoever wants to take it up can take it up. I'll just read it out. How could we stop EIA from becoming a legislation that harms pro-environment issues? Praveen or anybody who wants to take it up. Reddy sir, if you want to like to take, whoever.
Can I give a quick response?
Yeah.
You meant FRA, not ERA.
Okay. EIA, not how can we stop EIA is the question. How can
EIA from?
Becoming a legislation that harms pro-environment issues? I'm slightly confused.
He's saying environmental impact assessment.
No, I don't want to talk about it.
Anybody else wants to take it up?
Although I think Praveen has a lot of experience with mining projects and EIAs.
No,
maybe the question has to do with how EIs have legitimized development projects being set up in places with the understanding or with the assumption. Well, I don't know who actually has that assumption anymore, but definitely some parties tend to misuse that assumption, is that environmental impacts can be managed and mitigated, and so it's okay to put them through even if the environmental impact assessment says that these landscapes will be transformed completely and cannot be, they're irreversible changes and stuff like that. Maybe that's the question. How is a big, we should have another webinar on that.
A quick point related to that, since it's EIA. So let me just clarify that the Environment Protection Act does not deal with land. It is only about regulations. And EIA is the EIA 2020, what little I know of, is primarily trying to dilute those regulations on a variety of issues. Now, there are three layers. There is a forest clearance process, there is an environment clearance process, and there is a wildlife clearance process. And one of the biggest issues is that in the Lafarge judgment in 2011, a 3-judge bench laid down guidelines which said that environment clearance must not be granted till forest clearance is obtained, for the simple reason that forest clearance involves land. And there have been cases where project proponents, based on environment clearance, have gone ahead and obtained massive funding from institutions and later applied pressure. And what really used to happen on the ground is that a fait accompli situation would develop. The project proponent would start work outside and bring the highway to the two edges of the park and say, look, I've invested 500 crores. Now give me clearance. So therefore, these are all issues connected. And then there is the pesky issue of environment consultants. And it's become a huge racket. And there are NGOs, retired officials masquerading as experts, and there are huge consultancies and what have you that are exchanged, and the terms of reference are inaccurate, and it is written backwards to accommodate the company and the project, and you end up with a complete set of, and I will tell you, on the Hubli-Ankola railway, which we are dealing with in Karnataka right now, a very, very prestigious institution, a scientist, he claims to be a scientist of that institution, has written an EIA backwards to accommodate that project. And now when he is under attack in the media and all ecologists are attacking him, he's saying, let's have a debate after the horses have bolted. So this big racket of EIA consultants has to be curbed, and unless and until you have credible people looking at it. And EACs, where are the credible people on EACs? Where are the credible people on FAC and standing committee? So therefore, people are rubber stamping projects, and it's going through. Whether EIA 2020 comes in or not, It is happening. Your clearance rates are 99%, 98%. There's nothing, and there's no mitigation.
Yeah, we can keep talking about this for a long time. Do we have any question from the participants of this moot court? Because if there is not, we have one more question which has come from again YouTube. So I think we'll take this question. I think this question can be answered by Rita, because the question is this: Arunachal Assembly passing resolution to be added into the 6th schedule would give them the land rights. Hypothetically saying, if they get it done, will it help conservation?
I'm not sure whether I can, like from the law point of view, I'm not sure whether I'll be the right person to answer that. So the thing is that the only perspective I can give is that right now, again, it comes back to community and the rights of the government as such. There is a lot of focus on infrastructure development in Arunachal. Where we talked about earlier, where there's the Dibang Valley, where there's the Pake, the highway cutting across, the protected area, Pake, this thing. So I'm not sure how this will. I won't be the right person to answer this.
So anybody else wants to take it up? Maybe Mr. Reddy or Praveen, you've been on these issues. You have some grip on it.
I don't know much about that area.
I don't think that it's going to create any impact, because in any case, in Arunachal Pradesh, huge amount of projects are creeping in, they're entering, and they will be cleared. And therefore, whether it becomes a scheduled state and whatever, those aspects will not probably make such a huge impact, other than serious government policy, because the left hand of the government doesn't know what the right hand is doing. The Ministry of Environment, in my view, must act as brakes. The development ministries are the engine. Even a Ferrari needs good brakes, and the brakes are fading or are failing. So unless development ministry policies are tuned with the conservation imperatives of climate change and so forth, and forest fragmentation, etc., it is very difficult. So projects will creep in, Dibang will come in, X will come, Pake will come, all this will come. And for activists to fight it at ground level, or for communities to fight it at ground level, becomes very, very difficult. You can't do, there'll be a flood of projects. So we need to really look at this very carefully in terms of how we can balance conservation and development, and that is the reason why we have to debate on the sustainable landscapes model more than sustainable development.
Okay, so I think we'll give the participants some time. I had just a question. I mean, I've always wanted to ask this to Mr. Reddy, is that you have done a lot of voluntary relocations. I mean, and some of them have been really done well. So can you walk us through the process of how you ensured that the community didn't feel alienated or been pushed out of the villages? What all safeguard measures did you put in? What was the communication like? And how did you explain the nuances of the law or the packages that the government offers?
The issue itself is voluntary relocation. The word voluntary itself means they are moving out of that home place voluntarily. See, going out of a place doesn't mean our culture gets affected. See, I am working in Maharashtra, coming all the way from Andhra, but my Andhra culture is still here. Many people even go to US and they still keep their culture. Culture doesn't get affected. You are working in Mumbai, you may be from some village, and if not, if your forefathers from village, in search of now employment and livelihood, we go to the places, all of us. Here, the person who is moving out of the village, which is in a core area, be a better place is going because they don't want to stay in the village. Like Praveen has already said, they don't have the facilities like electricity, roads, medical facilities, schooling, and all those things. So they would like to go to a place which is better than their home and resettle themselves, so that they will give a space to the wild animals here, and also they will also get. It is a win-win situation here. Nothing is forced here. It is voluntary. The word itself is voluntary. And the package which is developed by the government of Maharashtra, it is better than many other states, because here we not only give 10 lakh rupees per family, but also we give the 4 times the value of the land, immovable property. No? So because the package is also very lucrative, so people are accepting. There are many villages which have passed the resolution to move out of the core area, and since there is shortage of money, so we are not able to do that. In this, here I would like to mention one thing. Like Mr. Praveen has already said, there are 10 crore tribals and more than 1 lakh crore rupees is being spent by MOTA, Minister of Tribal Affairs. So if a part of this money, which is spent for tribals, if they can even use it for voluntary relocation of the tribe PA to outside. See, ultimately the grants given by MOTA is for tribals for their welfare. So voluntary relocation is one process where they voluntarily would like to shift out, and they give the funding to the forest department for voluntary relocation. It will benefit the forest, and at the same time it will also add up for the conservation also. This is one suggestion. This is a forum, not the right money. One suggestion I am giving here. And since we also try to ensure that the entire village will shift to one place, so we go beyond what is given in the GR and also rules, and we'll try to settle the entire village at one place, so that their culture and relations, interrelations will not, get disturbed, and entire village will settle at one place. Like what is there inside core area, they will also settle at outside, so that entire community will stay at one place. This we will try to ensure. And also after coming out of the village, we will try to ensure the livelihoods by imparting different trainings. Like for women, we are giving trainings in stitching, and we are also reducing the dependency by providing them LPG connections, biogas connection for the women. And for youth, we are doing different skill kind of activities like driving, and also computer training, and also different trainings we are doing, so that they will be employed in service sector. So this is how forest department is hand holding in addition to what is as in the relocation package.
Okay, brilliant. So I think we've already close to 7:10. So maybe we can take maybe a few seconds to gather our thoughts, and then I would request, we can go through the closing comments one by one, each of the panelists, and either we can start with the same chronology with where we started with Mr. Reddy, or we can, whoever wants to go first can, just start. So that we have about 5 minutes each for giving your closing comments. Any volunteers for the closing comments to start, or should we just go as we started?
I can go, because I was I just wanted to sort of re-emphasize something about laws, because we've spoken so much about these different laws that are directly related to this particular context, and also the problems of implementation. I just feel that, coming from having worked with, understanding, or at least trying to follow multiple lawmaking processes. I mean, I have to say that the lawmaking processes have also involved many ordinances, which are completely a different ballgame altogether. So, not all lawmaking processes are actually, whether it's in the past and definitely now, have gone through very detailed thinking and open discussion and parliamentary debate and stuff like that. So we shouldn't expect laws to be perfect, to have come out of a very deliberative and open, transparent process, because that's not the kinds of laws we are dealing with mostly. But also, given that lawmaking has so much to do with politics, they're all very negotiated texts. And I mean, I don't think there's a single piece of legislation which has a very clearly defined outlook and perspective on the objectives that it is seeking to do. All of them are sort of tied up in these contradictions and gaps and fractures and all of that stuff. So to some extent, the implementation of every law requires us to apply much more than just a legal approach to get good things out of those laws. So I just wanted to, sort of reinforce the idea that even though we are all talking about issues that are very severely constrained by legal frameworks, it's up to us to actually go outside of that if it's necessary, and do those creative experiments about how things can actually play out finally on the ground. Because what we are finally interested in are good outcomes, not legal compliance per se. Legal compliance for something as important as conservation and social justice, I feel legal compliance is a very low bar. We can definitely try to aim for much beyond that and achieve the best outcomes given the circumstances, both in the case of social justice and conservation.
Thanks, Manju. Anybody who wants to go next, or should we? Yes, Praveen. Yeah, please.
Okay. So I think we should not be very despondent. And yes, we are passing through troubled times. And for young friends who are listening out there, there are solutions both within the legal framework and outside, within the constitutional framework and in the realm of policy, that you must all actively participate in these processes and drive these processes in the right direction. Now, the points that I want to make with respect to the subject today is that I reiterate that fragmentation is the most serious threat, both from development and from laws like FRA or human settlements. So the goal must be to defragment large blocks of intact forests, virgin forests, wherever they exist. And we need to come up with solutions, site-specific solutions, in order to ensure that spatially we separate humans and large wildlife. Now, that is simply because we cannot ignore ecological principles and experience that high density human populations simply living off the land cannot be in harmony with large wildlife. There are bound to be conflicts. It will create human wildlife conflicts and several other things. Why should my child study in a good school in Bangalore or wherever, while the tribal child must go to an ashram school which does not have a computer and is not exposed to digital? So if they desire so, it is a different matter if they want to remain. But as Mr. Reddy said, it's voluntary, and we need to allow them to take those. I've talked to many people. They have said, if you give us a package, we'll come out. So there are many such situations where this issue can be reconciled amicably to the benefit of both. We need to use those opportunities and ensure that social justice is delivered. And this whole one size fits all, saying that everything that works in Karnataka will work in the Northeast and so on, it's not going to deliver. So we need to craft those site-specific solutions. And for heaven's sake, we must not caricature this as some sort of a class struggle. It is not. And therefore, because in the class hierarchy, probably the lowest animals are far, far below than the most disenfranchised person. So we need to look at this carefully. And I'm pretty certain that there is a possibility that finally India will be able to reconcile this contentious issue only if we apply good knowledge.
Rita, would you like to go next?
Yeah, I think you know, the role of young lawyers. I mean, I think it's a great platform we are on right now and speaking to a very important audience, because I think it's very important right now to engage. Law is a very important space, and I think the last several months has shown that understanding it deeply and then carrying on amplifying your voice about whether it's about environment clearance, whether it's about community rights, whether it's protecting wildlife. I think understanding the law deeply for the youth who are involved in conservation is very important. And I think the young lawyers who are studying law right now, I think if you guys can take it forward in a more, you know, your engagement, I think, with the stakeholders, I think is very important. I think it's very important to increase that space, enhance that space, have more dialogues like this to, I think, deepen the understanding of law, which is linked to conservation, which is linked to development. And like the EIA draft 2020, I mean, it has a very, very huge implications on what's going to happen to environment, and especially in the Northeast also. So I think it's very important that these kind of dialogues, these kinds of debates with different stakeholders happen. And with the social media and with the platform of Zoom, I think it's very much possible to do that, you know. So I think if you guys can create more and more platforms and increase these debates, I think it'll bring much more clarity and reduce this gap between implementation, understanding law, and the role of law in conservation, I think. So I think you guys have a huge role to play. And I'm glad we are having this discussion like this today.
Thank you, Rita. Mr. Reddy, would you like to give your closing comment?
Thank you, Rishi. This is a very nice discussion. I am very thankful to Praveen Bhargava ji, Manju Menon, and Rita ji, and to all the young lawyers who are participants of this discussion. I will say a small message to see, these forests are our lungs, lungs of our earth. They take carbon dioxide in, they release the oxygen. Till that time, these forests are there on this earth, our oxygen security is always there. So we should all protect this forest. And also these are the sources of water. All the rivers which are in India are originating from this forest. So this source, if it is destroyed, the water security of this country is going to be damaged, definitely. Your oxygen security, water, you all know the climate change is happening. So whatever laws our country makes, they should take that our future generation should have this kind of security of water, oxygen, and the climate change, we should delay it as much as we can. So our laws should be in such a way that they should protect the forest, but also at the same time, they should provide the social justice to the human beings. This land, this earth is for all of us, including Homo sapiens. There are about 10 billion species who are living on this earth. So the laws which we make should also ensure their sustenance, And so if you see these young lawyers, so even our constitution under section 51A of our constitution speaks about fundamental duties. It says it is our fundamental duty of every citizen of this country to protect and improve natural environment, including forests, lakes, rivers, and wildlife, and have compassion towards these living creatures. It is our fundamental duty, which is enshrined in the constitution of this country. Even if you see the culture of this country, even the wild animals has been revered, they are worshipped. So we should not forget that they also need a space. In the process of providing space to humans, we should not take away the space from them, and also bring the climate change. This. So as young lawyers, I humbly request all of them to become voice for these voiceless creatures. not only for their existence, but also for our existence. Thank you.
Thank you, Mr. Reddy. I think you kind of reminded us of the crux of the matter, and it's not a debate about people versus the environment of forests or wildlife. What I'll do is I know it's for students, it's a lot of information and a lot of data that's been going on, and the history really goes very back of where these laws have come from and where our constitution, drives our acts. What we are probably trying to say is that one must understand the spirit of the law, and rather than just looking at compliances. Somebody spoke about law. It's not just about getting legal compliances, and we need to go beyond the legal compliances from here on. And generally, one, I'm sure all of us have definitely been a part of this debate, but for young lawyers, you might have not had the exposure, but that has been a serious debate where sides were very polarized on FRA versus the Wildlife Protection Act. But over the years, slowly we are kind of trying to understand that nobody is really against wildlife or against the rights of the people. It is about understanding that these certain laws and the way they have been drafted can have undesired consequences, and that can lead to a result that is not in favor of anybody. So as lawyers, I think the attempt that Wildlife Conservation Trust has done here is to put different aspects of the law in a perspective, looking at conservation of nature and rights of people, how it how the law, when not drafted well, actually gives headaches to people who are implementing how it creates confusion among people, and how it leaves scope for misinformation to percolate down to the last mile, and then it becomes completely out of hand to kind of explain or implement the law in the right spirit. We have also spoken about different aspects of how development has been equally responsible for destruction of wildlife, and not just wildlife but also displacement of marginalized communities in the forested areas. And the debate, I don't think there is any longer the debate that should we have development or should we have conservation of forest, or create what you call as, what some people at some point referred to them as museums of calling forest as a museum to showcase species and wildlife and things like that. I'm sure all of us who have been on this panel, and they have kind of looked at the changing aspirations with, especially with the connectivity and access to satellite television or mobile phones, and the aspirations of the youth, I'm sure, are very different to what they used to be. And we have seen several examples where people have actually gone out and said to the government that we would like to voluntarily resettle somewhere where there are more opportunities. So the question is, how can such aspirations be maintained? Of course, there are so many data that goes out at how much population will be now urbanized and things like that. But I'm looking at that urbanization also will have an impact on forests and all of those kinds of things. Given this situation, I think as lawyers, you need to really look at how you're going to not just defend a particular constituency in the court of law, but go beyond that and also see that what changes are required in these laws. Some of you can take up policy advocacy and governance related issues and make a very strong case for better governance through law. So I wouldn't like to talk much, but this is more or less, I think, the crux of it, where you can get into the sections of the laws and how what needs to be changed and not. But I think that's your homework, right, for the moot court. And we would like to wish you all the best for coming days. It's a very complex topic. It has different aspects. It has emotional content of traditional, or historical injustices inbuilt into it, to, the voice of the voiceless. So it's going to be pretty interesting for you guys to kind of dig it up. I'm sure there is enough and more material available if you have to kind of refer to anything. And of course, I'm sure WCT is always there if there are any questions that you may have to ask about. So with this, I think I'll wish all our participants in the moot court the very best. And we really look forward to very interesting arguments in the coming day, that is tomorrow. Also on behalf of Wildlife Conservation Trust, I'd really like to thank all the panelists. This has been a different experience when it comes to discussion about FRAs and Wildlife Protection Act. But we can see that the discussions are going beyond pointing fingers and how things are harming each other. So I think that this was a great discussion, and though it's on Zoom and it feels different, usually you sit on a platform and you kind of point, and sometimes somebody had to poke me that, someone is trying to make a point, because you can't see there are so many windows right now. So if I've missed something, please excuse me for that. And with this, I would hand over to Ria and Benesha, and if you would like to make the vote of thanks for the day.
With that, we have come to the end of our panel discussion for the evening. The Moot Court Association would like to thank all our panelists as well as our moderator for a scintillating and thought-provoking discussion. I would now like to request Ms. Ruchi Vagralkar, General Secretary of the MCA, and Mr. Devavrat Nimbalkar to give their vote of thanks.
Thank you, Ria. Mr. M.S. Reddy, Mr. Praveen Bhargava, Dr. Manju Menon, Mrs. Rita Banerjee, Mr. Rishikesh Chavan, participants, ladies and gentlemen, it has truly been a privilege for the Moot Court Association of Government Law College to organize and host this panel discussion in association with the Wildlife Conservation Trust and the Initiative for Climate Action. The panelists, through their enlightening discussion, have managed to highlight the different perspectives of this relevant contemporary issue. I would like to personally thank each and every one of the panelists for taking out their valuable time and providing an enriching educational experience for all the attendees of this panel discussion. Our moderator, Mr. Rishikesh Chavan, has led this panel discussion with utmost expertise and has managed to encapsulate the very purpose behind the current topic of conservation and the right of traditional forest dwellers, a topic which is very relevant to the current times. Mr. M.S. Reddy, Additional Principal Chief Conservator of Forest and Field Director of the Melghat Tiger Reserve. Mr. Reddy has helped us understand a unique perspective on this current issue through his extensive work as a part of the Forest Department in many different wildlife habitats. Managing Trustee of Wildlife First, Mr. Praveen Bhargava, has graced us with his presence and has shared his invaluable experience of almost 4 decades in wildlife conservation. His expertise in laws relating to environment and wildlife has given us an enlightening insight on the topic for this panel discussion. Dr. Manju Menon, Senior Fellow at the Center for Policy Research, has helped turn this panel discussion into an educational experience unlike any other. We are extremely grateful to her for her prompt consent and enthusiasm. Last but not the least, I'd like to thank Mrs. Rita Banerjee, founder and director of the Green Hub project. She has provided us with unique and valuable insights on the right of traditional forest dwellers. Her vast knowledge and experience on the ground realities of the current issue through her work with youth of different communities has greatly contributed to the quality for this panel discussion.
I would like to extend my sincere gratitude to Dr. Anish Andheria, Ms. Samyukta Chemurupati, Mrs. Anukriti Upadhyay, and Ms. Shrutika Mulay from the Wildlife Conservation Trust for their unyielding support and cooperation in the organization of this event. I would also like to thank Ms. Anaga Sasidharan from the Initiative for Climate Action, our knowledge partners for this event, for their support and enthusiasm. I would now like to thank the members of the Moot Court Association for their constant devotion towards the success of this competition. In particular, I would like to thank Ms. Ruchi Vagralkar, General Secretary of the Moot Court Association, and post holders of the MCA, Mr. Gaurang Samel, Ms. Aditya Deshinkar, Ms. Akshita Tiwari, Ms. Nishta Chaudhary, Ms. Binaisha Hansotia, Mr. Raman Saraf, Mr. Ruhan Shah, Mr. Abhishek Raj, Ms. Riya Narichania, and Ms. Riya Doshi. I would additionally like to thank Mr. Akhilesh Meneses for his constant devotion to the MCA and the organization of this competition. I would also like to extend my heartfelt gratitude to Ms. Shivangi Adani, former General Secretary, for unconditional support in the organization of this competition. The advisory board of the Moot Court Association, comprising of Mr. Ruben Vakil, Mr. Firoz Patel, and Mr. Shanay Bafna, have been a constant pillar of support and guidance. Their unyielding dedication to the MCA is irreplaceable, and I would like to express my heartfelt gratitude to them for their immense contribution. Finally, I would like to extend my gratitude to all teams from around the country that are participating in this competition. I truly hope that all participants have found this to be an enriching experience, and I wish everyone the best of luck for their rounds of the competition. Thank you and good night.
Thank you, everybody, especially panelists, for making the time. I know that a lot of you have a lot of important stuff happening, and I've been bombarding you with a lot of emails, and thank you for patiently reading through and making the time. Really value your time, and we hope to have your time again in the future to address more panels and more sessions. Thank you, tons and tons. Have a great evening. Best of luck to all the participants. I'll see you tomorrow and day after.
Thank you.
Thank you.